Hi, this is David Merlin. Just a quick reminder, there are materials of mine at thebookpatch.com. I go to thebookpatch.com, click on bookstore and search, and my last name, search, Merland, M-Y-R-L-A-N-D, brings you to a page with my publications on them. Hybertson versus United States, volumes 1 and 2. This is a publication I don't mention nearly enough. It's a book of citizens' initiatives, more than 100 of them in one place. There's almost, I think, a dozen proposed constitutional amendments, discussion about all of them. Just a wonderful idea, the citizens' initiative. There's a lot of problems you can take care of through the citizens' initiative. The left makes waste of everybody with a lot of their initiatives drives. Public vehicular travel. This is a brief and a criminal complaint about the fact it's racketeering. The Motor Vehicle Code's never been written to apply to anybody other than those using the highway as a place of business. It's a statutory analysis based on Washington State, but I suspect it's the same everywhere. The original motor vehicle codes were only written to apply to commerce, and they've never been broadened through an expression of legislative intent to embrace new objects within the scope of the law. Take from Caesar, volumes 1 and 2. Volume 1 is a complaint to Congress, January 1st of 06, to 80 members of Congress. Key issues about the tax code, especially, you watch my other videos here on YouTube, Key to the Code video, and the Section 83 tutorial, very big, and then there's the supplemental briefing of 014, several years later, 8 years later. Codebreaker, the Section 83 equation. I'm still the only one in the known universe teaching this application of tax code Section 83 to every paycheck. Everybody agrees it applies to all compensation, and they won't talk about it. They'll penalize you for asking in tax court. And currently, and it happens to be February 2nd, 2018, 2 or 3 people will be petitioning the Supreme Court with that involved very soon, right out of my office. The last one, 2 POTUS. This is a criminal complaint filed with the new president, Inauguration Day, about these very issues. And so peruse thebookpatch.com in their bookstore. Search for my last name, Merland, M-Y-R-L-A-N-D. Now, to our featured content. Thank you. Hi, this is David Merlin. We're going to look at Rodney Class versus United States. A victory, if you can believe it, albeit slight. Victory, if you can believe it, that's not a vote of no confidence against Rod Class. That's a comment on the state of the judiciary. For somebody in the vein of protest or whistleblowing to actually be heard by the Supreme Court is one thing, and to get a favorable decision out of it is another. However, it's very slight. The victory was a no-brainer. When you're done, you look at what the circuit court allowed the Supreme Court to be bothered with. I view the circuit court as having a desire simply to screw with Rod Class and make him go to the Supreme Court to get a favorable judgment. They should have handled it on the appellate level. So for this installment of the Codebreaker curriculum, we're going to look at specifically the rights to challenge the constitutionality of a statute. While that's far outside the realm of tax law, the application of this particular element of criminal procedure and jurisprudence is very important, because we have Rod Class, who challenged the constitutionality of the charging statute in Washington, D.C., and that was after he pled guilty. So he's waived facts of the case. He's guilty under that statute. But he challenged the constitutionality of the statute in an appeal after waiving all rights to appeal. And the question all the way to the Supreme Court was, Can somebody who pleads guilty challenge the constitutionality of the charging statute? Of course they can. It's well established. It's everywhere. You don't even have to ask. Pardon me. So it is a no-brainer, but it's important how much gravity a constitutional challenge to the charging statute really comes with the defendant, despite having pled guilty to the facts. Can he still make a challenge to his conviction? Yeah. If it's unconstitutional to begin with, you're going to see, because this is work I did several years ago here on the Ninth Circuit, you'll see Ninth Circuit cases cited, which of course is research that has to be translated into your circuit by you finding case law on your circuit that says the same thing. So, yes, you can appeal even though you pled guilty. And that's at the core of the Rod class appeal. The D.C. Circuit said, no, you waived all your rights. And the Supreme Court said, it's not a right of his to challenge the constitutionality of the statute. Because if it's unconstitutional, there's no offense. And if there's no offense, there's no subject matter jurisdiction. There's no action before the court. It has to be an offense, a violation of a criminal statute. The criminal statute has to be constitutional. Period. And he's challenged the statute as unconstitutional, saying it infringes on his Second Amendment rights. And under the Fifth Amendment, saying no reasonable person would know that that law would exist, or that by reading it, it doesn't tell you that what he did, he feels, would be viewed as illegal by a person that reads the statute, which generally is the umbrella of the void for vagueness challenge, anywhere you make it. So it's Second and Fifth Amendment challenges he made on appeal. They said, you can't do that. You waived your rights because you pled guilty. And he says, yes, I can. All the way to the Supreme Court. The Supreme Court agreed. So we're going to look, I'm going to read particular parts of the decision. I'm not going to go through the whole thing. A lengthy decision. So the Supreme Court paid respect to the topic. And there's a dissenting opinion by Alito, Thomas, and I think Breyer, that are blown out of the water. It's one dissenting opinion with which two other justices join. Alito wrote the dissent. And when you see it, and what I have to say in relation to it, and the authorities I cite, there's a great reason to say that the dissent really lost it. They came close to abolishing a right or two in their dissent. If that's the way the court had gone, it's bad news. So anyway, it is a no-brainer, and we're going to get to the decision now by doing this. Here it is, October term of 2017, Class versus United States. And you see that it was decided February 21st, 2018. This is hot off the press. Today is February 25th. A federal grand jury indicted the petitioner, Rodney Class, for possessing... First, I should say, this is not the opinion. This is the syllabus. The syllabus is, note, where it is feasible, a syllabus, or head note, will be released, as is being done in connection with this case. At the time the opinion is issued, the syllabus constitutes no part of the opinion of the court, but has been prepared by the reporter of decisions for the convenience of the reader. See United States versus Detroit Timber. Okay? So the syllabus is not part of the opinion, it's an overview. A head note. A federal grand jury indicted the petitioner, Rodney Class, for possessing firearms in his locked Jeep, which was parked on the grounds of the United States Capitol in Washington, D.C. An individual may not carry on the grounds or in any of the Capitol buildings a firearm. They were in his locked Jeep, and the statute says you may not carry. Is that carrying or is that transporting? Appearing pro se, Class asked the district court to dismiss the indictment. He alleged that the statute violates the Second Amendment and the Due Process Clause. After the district court dismissed both claims, Class pleaded guilty to possession of firearms. A written plea agreement set forth the terms of his guilty plea, including several categories of rights that he agreed to waive. You can't do that. You can't waive categories of rights. They have to be specifically enumerated, listed in the plea agreement. Period. And we'll get to the reasons. The agreement said nothing about the right to challenge on direct appeal the constitutionality of the statute of conviction. That's right. There are certain challenges you can't waive. You can't waive ineffective counsel. But if you plead ineffective counsel trying to get your conviction vacated, you have to show that actions by the counsel prejudice you. You can't just make a blanket challenge on ineffective counsel. Anyway, after conducting a hearing pursuant to Rule 11 of the Federal Criminal Rules, the district court accepted Class's guilty plea and sentenced him. Soon thereafter, Class sought to raise his constitutional claims on direct appeal. The Court of Appeals held that Class could not do so because, by pleading guilty, he had waived his constitutional claims. Well, what if the court gets authority unconstitutionally? And then they exercise that authority. You're going to jail, pal. They exercised that authority. What if it was derived from an unconstitutional basis or process? That's where the challenge comes in. So it doesn't matter. Did they exercise authority they would have had they not committed what I'm saying is an unconstitutional breach? And as was held, and this is again the syllabus, a guilty plea by itself does not bar a federal criminal defendant from challenging the constitutionality of his statute of conviction on direct appeal. How about that? Because you can't send me to prison unconstitutionally. It's that big and broad. What can the dissent possibly have to say that stands that bedrock on its head? Of course I can challenge unconstitutional imprisonment. This holding flows directly from this court's prior decisions. Right. 50 years ago, in Haynes v. United States, the courts addressed a similar claim challenging the constitutionality of a criminal statute. Justice Harlan's opinion for the court stated that the defendant's plea of guilty did not, of course, waive his previous constitutional claim. That clear statement reflects an understanding of the nature of guilty pleas that stretches in broad outline nearly 150 years. Subsequent decisions have elaborated upon it. In Blackledge v. Perry, very important case, this court recognized that a guilty plea bars some antecedent constitutional violations related to events such as grand jury proceedings that occur prior to the entry of the guilty plea. See? Specific exceptions. There are things you can waive. The court didn't get authority through that. It's related to the trial. However, where the claim implicates the very power of the state to prosecute the defendant, a guilty plea cannot by itself bar it. The guilty plea cannot bar the claim if it's about whether the state had the power to even prosecute. It's a different level of collateral attack on the conviction, isn't it? It's not about procedure. It's about, excuse me, but there's a certain point where the court should have just said, there's no case here, case closed. Next case, please. And just walked away. Likewise, in Mena versus New York, the court held that because the defendant's claim was that the state may not convict him no matter how validly his factual guilt is established, his guilty plea therefore did not bar the claim. Exactly. In more recent years, the court has reaffirmed the Mena-Blackledge doctrine's basic teaching that a plea of guilty to a charge does not waive a claim that, judged on its face, the charge is one which the state may not constitutionally prosecute. Right after I read B and C, I want to touch on Carol Ann Bond versus United States in relation to the paragraph we just read. In this case, Class neither expressly nor implicitly waived his constitutional claims by pleading guilty. As this court understands them, the claims at issue here do not contradict the terms of the indictment or the written plea agreement, and they can be resolved on the basis of the existing record. So there's no new evidence, no new witnesses. It's really about the core issue of constitutionality, and the lower court should have heard it. Class challenges the government's power to criminalize his admitted conduct and thereby calls into question the government's power to constitutionally prosecute him. A guilty plea does not bar a direct appeal in these circumstances. That's right. And that's what the court decides. Federal Rule of Criminal Procedure 11A2, which governs conditional guilty pleas, cannot resolve this case. By its own terms, the rule does not say whether it sets forth the exclusive procedure for a defendant to preserve a constitutional claim following a guilty plea. And the rule's drafters acknowledge that the Supreme Court has held that certain kinds of constitutional objections may be raised after a plea of guilty, and specifically stated that Rule 11A2 has no application to the kinds of constitutional objections that may be raised under the Mena-Blackledge doctrine. Because of the applicability of the Mena-Blackledge doctrine is at issue here. Because the applicability of the Mena-Blackledge doctrine is at issue here, 11 Rule A2 cannot resolve this case. It's reversed. It's reversed, not the conviction, just the opinion that we're just the appellate court and you waived your rights to raise this when you signed your plea agreement, so we're not going to hear the issues. That's all the Supreme Court reversed. So it's really a very slight victory. They didn't say he's not guilty. However, now when he goes to the lower level, the appellate court has to say whether or not the charging statute violates Second and Fifth Amendment rights. Okay? Now back to this paragraph A. However, where a claim implicates the very power of the state, Carol Ann Bond went all the way to the Supreme Court. I think the first time, she went twice. The first time, 2011, I believe it was, the Supreme Court got the question of the 10th Amendment claim that she raised. The statute she was charged under is a federal statute. It really shouldn't reach her conduct, which is a local crime. And so it violates states' rights. And the U.S. District Court said you don't have standing to raise a states' rights issue. And the appellate court said likewise. And so all the way to the Supreme Court, Carol Ann Bond versus United States, there's a law that was a federal statute written to implement a treaty against using chemical weapons in times of war. Carol Ann Bond learned that a certain woman had cheated with Carol's husband. And she took it upon herself to put caustic substances. She was a biologist or a chemist, and she had access to caustic substances. And she put some on the doorknob, front doorknob, I think, the mailbox handle, and the car door handle of this other woman. And it didn't kill her or anything, but caused a rash and irritation and doctor's visits. And the Fed charged her under that warfare statute about chemical weapons. And all the way to the Supreme Court, I have standing to argue under the 10th Amendment. This law is being used to reach me, but it's unconstitutional for the fact that it comes into a state and infringes on the state police power. And everybody said, you don't have standing. A state has to argue that. And the Supreme Court said, no, she can argue that. If the law is being used to reach her and it breaches the Constitution in some way, she has every right to raise the argument. It's a direct effect on her. And so it went back to the lower level, and they said, no, it doesn't violate states' rights. All the way to the Supreme Court, and the Supreme Court says, yeah, it does. This is a local crime. Anyway, the separate concurring opinion, as we'll see later on, the separate concurring opinion in the Bond case by Ruth Bader Ginsburg is fabulous about the right to challenge a prosecution in the instance of, right here, start here in the paragraph, however, where the claim implicates the very power of the state to prosecute the defendant, a guilty plea cannot by itself bar the claim. Exactly. That's the big point that doesn't come from this decision. It's a revisitation of that point that resolves this controversy in this decision. Okay? That's all that is. Now, what I've got over here is bookmarks, as you see, and we were just at the syllabus. Now we'll go forward to the opinion. The opinion, and again, I'm only going to read the yellow portions. Most of this is about my commentary regarding the decision. I was wrong on who was in the dissent. I thought it was Breyer. No, he delivered the opinion of the court. Does a guilty plea bar a criminal defendant from later appealing his conviction on the grounds that the statute of conviction violates the Constitution? In our view, a guilty plea by itself does not bar that appeal. Okay, thanks. That's very straightforward. That's what was decided. And so it's not about gun rights. It's not about the patriot movement or any of the things for which Rod Class is infamous, notorious, or famous for arguing or writing. It's about only that. In sum, the claims at issue here do not fall within any of the categories of the claims that that Class's plea agreement forbids him to raise on direct appeal. See, in his plea agreement, he waived general categories of rights, but these claims don't fall into the categories that he waived. They challenge the government's power to criminalize Class's admitted conduct. They thereby call into question the government's power to constitutionally prosecute him. A guilty plea does not bar a direct appeal in these circumstances. We are not convinced by the three basic arguments that the government and the dissent make in reply. Of course they're not convinced. They're in the majority opinion. That's what being in the majority is about in relation to the... Anyway, that's oxymoronic right there. I'm sorry, redundant. First, the government contends that by entering a guilty plea, Class inherently relinquished his constitutional claims. The government is correct that a guilty plea does implicitly waive some claims, including some constitutional claims, like right to a jury trial. However, as we explained in Part 2, supra, above, Class's valid guilty plea does not by itself bar direct appeal of his constitutional claims in these circumstances. As an initial matter, a valid guilty plea foregoes not only a fair trial, but also other accompanying constitutional guarantees. While those simultaneously relinquished rights include the privilege against compulsory self-incrimination, the jury trial right, and the right to confront accusers, they do not include a waiver of the privileges which exist beyond the confines of the trial. Listen to these last 45 seconds again and again and again. This is bedrock. It's not about the trial. It's about whether or not you had the authority to put me in prison with that statute. Here, Class's statutory right directly to appeal his conviction cannot in any way be characterized as part of the trial. Statutory right to directly appeal. Yeah, there's a statute that says you can appeal decisions of the district court. A valid guilty plea also renders irrelevant, and thereby prevents the defendant from appealing, the constitutionality of case-related government conduct that takes place before the guilty plea is entered. See Herring, Supra, holding a valid guilty plea results in a defendant's loss of any meaningful opportunity he might otherwise have had to challenge the admissibility of evidence obtained in violation of the Fourth Amendment. There's a great example of something that you can waive. Neither can the defendant later complain that the indicting grand jury was unconstitutionally selected. But as we have said, those kinds of claims are not at issue here. Finally, a valid guilty plea relinquishes any claim that would contradict the admissions necessarily made upon entry of a voluntary guilty plea. But the constitutional claim at issue here is consistent with Class's admission that he engaged in the conduct alleged in the indictment. Unlike the defendants in the Brosi case, Class's challenge does not in any way deny that he engaged in the conduct to which he admitted. Instead, like the defendants in Blackledge and Mena, he seeks to raise a claim which, judged on its face, based upon the existing record, would extinguish the government's power to constitutionally prosecute the defendant if the claim were successful. That's a totally different foundation for challenge than the other rights that you do waive with a guilty plea. This is about their authority, not about admitting to conduct and waiving rights that allow them to move forward, like your right to a trial. Well, you're waiving that. You're pleading guilty. This is entirely different. It's about whether or not they can even get you there. The second thing the government says, second, the government and the dissent point to Rule 11A2 in the Federal Rules of Criminal Procedure, which govern conditional guilty pleas. The rule states, conditional plea. With the consent of the court and the government, a defendant may enter a conditional plea of guilty or nolo contendere, reserving in writing the right to have an appellate court review an adverse determination of a specified pretrial motion. A defendant who prevails on appeal may then withdraw the plea. The government and the dissent argue that Rule 11A2 means that a defendant who pleads guilty cannot challenge his conviction on appeal on a forfeitable or waivable ground that he either failed to present to the district court or failed to reserve in writing. That's pretty much true. Was it forfeitable or waivable? There's some things you can't waive. I can't give them authority by pleading guilty. They have to have authority with or without me. They support this argument by pointing to the notes of the advisory committee, which said, in particular, the dissent points to the suggestion that an unconditional guilty plea constitutes a waiver of non-jurisdictional defects, while the government points to the drafter's statement that they intended the rule's conditional plea procedure to conserve prosecutorial and judicial resources and advance speedy trial objectives, while ensuring much-needed uniformity in the federal system on this matter. The government adds that its interpretation of the rule furthers these basic purposes, and the argument goes just as defendants must use Rule 11A2's procedure to preserve, for instance, Fourth Amendment unlawful search and seizure claims, so must they use it to preserve the constitutional claims at issue here. The problem with this argument is that, by its own terms, the rule itself does not say whether it sets forth the exclusive procedure for a defendant to preserve a constitutional claim following a guilty plea. Oh, those details will get you. It doesn't say these are the only ways. Oh, thanks, man. Man, that's poetry. It has to, and the reason why. It goes back to, you just can't waive categories. The plea agreement has to be specific. I make no apologies. And there's a very specific, big, broad reason for that we're going to get to. At the same time, the drafter's notes acknowledges that the Supreme Court has held certain kinds of constitutional objections may be raised after a guilty plea. Thanks. Let's skip down half the paragraph. The applicability of the Men of Blackledge doctrine is at issue in this case. See the Brochie decision acknowledging that Men in Blackledge as covering claims where on the face of the record the court had no power to enter the conviction or impose the sentence. That's the level of attack that Rod Class won upon which he won. We therefore hold that Rule 11A2 cannot reserve this issue. The third reason the government says we should prevail, that they're not convinced by. Third, the government argues that Class expressly waived his right to appeal his constitutional claim. The government concedes that the written plea agreement, which sets forth the complete agreement, that's in quotes, the complete agreement between Class and the government. Excuse me, pardon me a second. Listen again. The government concedes that the written plea agreement, which sets forth the complete agreement between Class and the government, does not contain this waiver. Well, then why are you arguing that he waived that right? That you can waive it implicitly or generally in some category? No, you can't. It has to be a specific waiver for very specific reasons that are undeniable and well established. This should have never gone to the Supreme Court. The D.C. Circuit wanted to mess with Rod Class by pushing him up. Rather, the government relies on the fact that during the Rule 11 colloquy, the discussion about the guilty plea, the district court judge stated that under the written plea agreement, Class was giving up his right to appeal his conviction, and Class agreed. Well, it has to be in the plea agreement. That's what he signed. He didn't sign the judge's warning. And the counsel advised him more than likely about the terms of the plea agreement and not what the judge said. We do not see why the district court judge's statement should bar Class's constitutional claims. It was made to ensure Class understood the terms of any plea agreement provision waiving the right to appeal or to collaterally attack the sentence. It was so that he understood the terms of the plea agreement, not so they understood things that aren't in the plea agreement. And they concede this stipulation, this particular waiver, is not in the agreement. It does not expressly refer to a waiver of the appeal right here at issue, right? And if it is interpreted as expressly including that appeal right, it was wrong, as the government acknowledged at oral arguments. Under these circumstances, Class's acquiescence neither expressly nor implicitly waived his rights to appeal his constitutional claims. For these reasons, we hold that Rodney Class may pursue his constitutional claims on direct appeal. The contrary judgment of the Court of Appeals for the District of Columbia is reversed, and the case is remanded for further proceedings consistent with this opinion. He has to go back to appeals, and they will have to decide whether or not the Second and Fifth Amendment are infringed or compromised by the conduct complained of. Whether they unconstitutionally obtained authority to get them where he is. Now, the sentence in this case is only 24 days with a year of supervised release. So it's almost a non-issue. I think he served as many as 24 days. So it would be time served and they could all move on. But he chased his constitutional challenge all the way to the Supreme Court. Now the appellate court has to, again, face the issues, but this time they have to write a memorandum. Ha ha ha. We're in we read the conclusion of the case of the majority, and now we're at the punchline, the dissenting opinion. Justice Alito, Kennedy, and Thomas join Alito in this dissenting opinion. And what they have to say, notice they don't point toward, this is about the government's authority. You have every right to challenge the government's authority constitutionally. That if the government doesn't have that authority constitutionally, They got no business taking you to jail, do they? Big principles for the majority opinion. And listen to how slimly the dissenters slice a defense of their decision that no, he should be barred from his challenges. Roughly 95% of felony cases in the federal and state courts are resolved by guilty pleas, according to, this is at footnote 1 of the dissent, United States Sentencing Commission Report 2017. Okay? Yeah, right now. 95% of the system, 95% of the cases, guilty pleas. Therefore, it is critically important that defendants, prosecutors, and judges understand the consequences of these pleas. I got an idea. How about you understand the conditions of these pleas so you don't enter them in the first place? So that 95% rate goes down a ways. In this case, the parties have asked us to identify the claims that a defendant can raise on appeal after entering an unconditional guilty plea. Regrettably, the court provides no clear answer. Wrong. The court said it's not expressly listed in the guilty plea, and so it's not waived. That's the answer. By my count, the court identifies no fewer than 5 rules for ascertaining the issues that can be raised. According to the court, a defendant who pleads guilty may assert on appeal, and he lists 5. They aren't rules for ascertaining the issues that can be raised. They're 5 different sorts of challenges that can be raised, not 5 different methods for ascertaining the challenges that can be raised. 5 different types of challenges that can be raised. So right there, the foundation for this protest in the defense, in the dissent, is flawed. You look at the very beginning of reasoning in a dissent very closely, and you might find often the very foundation for the reason they parted ways. And in most instances, there will be a flaw in the dissent's reasoning. According to the court, a defendant who pleads guilty may assert as an appeal on number 1, a claim that implicates the very power of the state to prosecute him. Correct. 2, a claim that does not contradict the facts alleged in the charging document. That's a condition, not a type of challenge, like the first one is. 3, a claim that the facts alleged and admitted do not constitute a crime. That's a Fifth Amendment claim. Might be a First Amendment claim. That's constitutional. And 4, claims other than case-related constitutional defects that occurred prior to the entry of the guilty plea. Correct. Mena and Blackledge both said that. He covered 4 of them there. Then he takes on the 5th one here. In addition, the court suggests 5, that such a defendant may not be able to assert a claim that contradicts the terms of the written plea agreement, but whether this rule applies when the claim falls into one of the prior 4 categories is left unclear. That's all. Sort it out. It's going to be different in every case. How these rules fit together is anybody's guess. Don't guess. It's going to be different in every case. Take on the facts, fit them to, and then determine whether or not it fits into one of these exceptions. And to make matters worse, the court also fails to make clear whether its holding is based on the Constitution or some other ground. No, they didn't. They said it has to be specifically listed. Didn't they cite a couple cases? There is no justification for the muddle left by today's decision. Right there. There is no problem here. And they call it a muddle. This is the dissenting opinion. Kennedy, Thomas, and Alito. The question at issue is not conceptually complex. In determining whether a plea of guilty prevents a defendant in federal or state court from raising a particular issue on appeal, the first question is whether the federal Constitution precludes a waiver. If the federal Constitution permits a waiver, the next question is whether some other law nevertheless bars a waiver. They're looking for a law that says you can't waive this right. Well, what if Congress didn't think of that right when they wrote what you can waive? They're looking for congressional guidance about constitutional rights you can and cannot waive? There's another huge flaw in the reasoning in the dissent. And if no law prevents the waiver, the final question is whether the defendant knowingly and intelligently waived the right to raise the issue or the claim on appeal. What if, in fact, the government had no authority to prosecute the guy? Well, you waived that right. Meaning your waiver gives the government the authority because they didn't have it without the waiver. How can you waive authority to the government? I thought you had to be guilty to go to prison. Do you see how far off even keel I just knocked the dissenting opinion? Just in a couple of paragraphs, their foundation is totally flawed. And they go on and on about it. Petitioner Rodney Class was charged with violating a federal statute that forbids the carrying of firearms on the grounds. After entering an unconditional guilty plea, he appealed his conviction, asserting that his conduct was protected by the Second Amendment and that the statute he violated is unconstitutionally vague. The Court of Appeals affirmed his conviction, holding that Class had relinquished his right to litigate these claims when he entered his unconditional plea. Analyzing this case under the framework set out above, well, don't do that. I think the Court of Appeals was clearly correct. First, the federal Constitution does not prohibit the waiver of the rights Class asserts. We have held that most personal constitutional rights may be waived, and Class concedes that this is so with respect to the rights he is asserting. It's not up for him to concede. It's up for the court to determine whether or not you can waive that right, thereby giving the courts authority. And they cite a 1991 Supreme Court case, of course, Peretz versus United States, when they said, we have held that most personal constitutional rights may be waived. They cite that case, and Class concedes that this is so with respect to the rights. But they didn't say, when they cited Peretz, they didn't say, due to the Peretz case, he waived these rights. They simply say, Class conceded that he waived these rights. Well, I want it from not a layperson like Class. Second, no federal statute or rules bar waiver. On the contrary, Rule 11 of the Federal Criminal Rules makes it clear, with one exception that I will discuss below: a defendant who enters an unconditional plea waives all non-jurisdictional claims. Well, if you don't have the authority to prosecute them, I think it's kind of a jurisdictional claim, don't you? And if it's because of the Constitution, I think you should be allowed to raise that claim if it relieves you of the authority to put him in prison. That's a jurisdictional claim. Although the rule does not say this expressly, that is the unmistakable implication of subdivision A2, which allows a defendant, with the consent of the court and the government, to enter a conditional plea of guilty or nolle contendere, reserving in writing the right to have an appellate court review an adverse determination of a specified pretrial motion. Where a law explicitly enumerates certain exceptions to a general prohibition, additional exceptions are not to be implied in the absence of evidence of a contrary intent. And here there is strong evidence confirming that other exceptions were ruled out. Well, I'd like to see the law Congress wrote that says, if the court lacks authority, but the defendant signs a plea agreement, the court now has the authority to proceed. That's the law I'd like to see. Because all the time when you challenge in tax cases, oh, we don't have the authority to hear this, the Anti-Injunction Act or the Declaratory Judgment Act, we can't hear tax cases. And they'll tell you what Congress allows them to hear and what allows them not to hear. Well, if you're getting authority, it better come from Congress, because you claim all the time that's where your authority comes from. And here they're saying, well, no, our authority could come from a plea agreement and a waiver. So here's the dissent's conclusion. Sure. Thus, to the extent a certain case reflects an understanding of the nature of guilty pleas, it reflects nothing more than the idea that a defendant can assert jurisdictional defects even after pleading guilty. Oh, this is the dissenting conclusion, okay? That rule is utterly unremarkable and of no help to class. Today, as well as at the time of the founding, federal courts have jurisdiction over cases charging federal crimes. And what if it's unconstitutional? Then you don't have jurisdiction over the charging crime. That's just a fact. As early as the 1830, the court rejected the suggestion that a federal court is deprived of jurisdiction if the indictment charges an offense not punishable criminally according to the law of the land. We have repeatedly reaffirmed that proposition. And I'm going to skip down here. You can read this decision. You can find it anywhere. This is the dissent's conclusion. And let's back up here, just the last paragraph. In sum, the governing law in the present case is Rule 11 of the federal criminal rules, not the Constitution. Okay. Under that rule, an unconditional guilty plea waives all non-jurisdictional, right, sure, but not jurisdictional. All non-jurisdictional claims, with the possible exception of Mena-Blackledge doctrine created years ago by this court. That's correct. But he said non-jurisdictional. That doctrine is vacuous, has no sound foundation, and produces nothing but confusion. At a minimum, I would limit the doctrine to the particular types of claims involved in those cases. I certainly would not expand its reach. I fear that today's decision will bedevil the lower courts. I respectfully dissent. You can raise constitutional issues on appeal. And here's why it has to be specifically stated in the plea agreement. Watch this. Ninth Circuit, September 13th, 2004. The decision filed February 2005. The case of Geronimo versus United States. We lack jurisdiction to entertain appeals where there was a valid and enforceable waiver of the right to appeal. And they cite U.S. versus Vences. It would overreach our jurisdiction to entertain an appeal when the plea agreement effectively deprived us of jurisdiction. We review de novo whether a defendant has waived his right to appeal by entering into a plea agreement and the validity of such a waiver. See United States versus Ventre. A defendant's waiver of his appellate rights is enforceable if 1. The language of the waiver encompasses his right to appeal on the grounds raised, and 2. If the waiver is knowingly and voluntarily made. Okay. We first must address the issue of whether Geronimo's waiver of his right to appeal precludes his challenge on direct appeal to the district court's rejection of his request to withdraw his guilty plea based on his assertion that fair and just reasons supported a change of plea. Our analysis begins with the fundamental rule that plea agreements are contractual in nature and are measured by contract law standards. This customary reliance on contract law applies to interpretation of an appeals waiver within a plea agreement, and we will generally enforce the plain language of a plea agreement if it is clear and unambiguous on its face. Here, Geronimo's plea agreement provides in pertinent part that by accepting the benefits of this agreement, and if sentenced by the court to a term of imprisonment of less than statutory maximum of 20 years, Mr. Geronimo waives any and all rights to appeal, and all his waivable statutory rights to file a petition pursuant to 2255, which says you can collaterally attack a conviction, challenging the length of his sentence. This language plainly states that Geronimo waived his rights to appeal his sentence on any and all grounds in exchange for a sentence of less than 20 years and various other benefits under the agreement. Thus, based on Martinez and Nunez, we conclude that Geronimo's plea agreement clearly encompasses his right to bring the present appeal. Not every appeal, the present appeal, where he wanted to withdraw his guilty plea. It wasn't that the state lacks the authority to prosecute him. Back to the punchline, the dissenting opinion. Like I said, I did research for the Ninth Circuit on this several years ago, so the annotations won't contain 2015, 2016. However, things you got to know. I have these little thought bubbles I added. The first one, jurisdictional defects can include the constitutionality of the charging statute as applied to the defendant's conduct. See Mercer versus U.S., or U.S. versus Mercer, Ninth Circuit, 1955. U.S. versus Caparel, Ninth Circuit, 1991. And they cite U.S. versus Montilla, Ninth Circuit, 1989. Jurisdictional defects can include the unconstitutionality of the charging statute. It's a jurisdictional challenge. It's not a non-jurisdictional challenge that you can simply waive. That's why I say the D.C. Circuit Court wanted to just make him go to the Supreme Court for a decision. They didn't care. A district court, by definition, abuses its discretion when it makes an error of law. Error is plain where it is clear and obvious. A plea of guilty, does not waive a claim that a charge is one which the government constitutionally may not prosecute. Thank you. It's already been decided. U.S. versus Cortez, Ninth Circuit, 1992. The Mena case, Supreme Court, that we just heard about, 1975. And Blackledge versus Perry, 1974. The exception is derived from the fact that even though the guilty plea removes the question of defendant's guilt from the case, Rod Class pled guilty, the issue of whether the government had the power to bring the charge at all still remains. Exactly. A showing of actual innocence is not time barred. And that's about the statute of limitations. You got 1 year to bring a collateral challenge of non-jurisdictional claims. But jurisdictional claims, they can linger. They might not be time barred, such as, I can prove I'm innocent. Further, plaintiff's guilty plea, this is copy and pasted from a lawsuit I wrote for somebody that's challenging a conviction. They have to sue to challenge their conviction. They're the plaintiff. Further, plaintiff's plea agreement as a contract does not refer to 28 U.S.C. 2255. I can challenge under 2255. I didn't waive that. It's not in the plea agreement. As a contract, it does not reference 28 U.S.C. 2255, which means all rights to file a motion to vacate a sentence thereunder are preserved. If it's not in the plea agreement, it's preserved. See Katie versus United States out of New York, U.S. District Court, 97. He was afraid he would violate his plea agreement if he challenged his conviction. And so he filed for declaratory judgment, a lawsuit, saying, hey, I want the court to declare that I'm not in violation of my plea agreement if I sue under 2255 for vacation of conviction. And the court said it's not in the plea agreement, and if the government thought you should waive that right, it would be in the plea agreement. A plea agreement is enforced against the people that drafted the plea agreement. So yeah, you can challenge your conviction. See how that works? It's a contract. It has to be specific. There's no muddle left by the majority opinion. What are you afraid of? It's a contract. The only thing to be afraid of is the ineffectiveness and incompetence of the people drafting the plea agreement. If you have a source of remedy, listen to this. I'm continuing now. In Katie, plaintiff feared violation of a plea agreement by filing a 2255 motion or lawsuit and sued for declaratory judgment prior to such a filing for a preemptive ruling to avoid possible breach of the plea agreement. And since 2255 wasn't in the plea agreement, it's preserved. Well, also not specifically referenced in the plaintiff's plea agreement are the Declaratory Judgments Act, 28 U.S.C. 2201 and 2202. It's a source of remedy. It's not a source of jurisdiction, but it's a source of remedy. I want a declaratory judgment that my conduct was illegal. They can't say, well, you waived rights. No, I didn't. Where's 2201 and 2202 in the plea agreement? You also have rights to remedy under the Administrative Procedures Act, 5 U.S.C. 701 through 706. I don't see that in my plea agreement. Well, that's where I'm suing. And I don't see the First, Fourth, Fifth, and Sixth Amendments to the Constitution in my plea agreement. Whatever other ones you want to raise, they're not in my plea agreement, and it's a source of remedy, and the contract does not waive that remedy, so it's preserved. See how I'm romping on the dissenting opinion. All of this was settled. There's no muddle. It's called contract law. It's specific or it's void. It's construed against the party that wrote the contract. Thought bubble number 2. The court lacked jurisdiction over the alleged offense for how the charging statute was used to punish protected speech. This is out of another brief I wrote. Jurisdictional defects can include the unconstitutionality of charging statute. We just read that. A federal court is required to determine jurisdiction on its own, sua sponte. Find your jurisdiction at every juncture. The courts are required to do it themselves. I shouldn't have to challenge jurisdiction. If the statute is unconstitutional, they have to put the brakes on, bring down the gavel, and move on to the next case. Here's a Supreme Court case that says a federal court is required to determine its jurisdiction on its own. A court must determine whether jurisdiction exists pursuant to Article 3 of the U.S. Constitution, and it must dismiss an action if jurisdiction is lacking. Thank you. The burden of proving jurisdiction is upon the party asserting it. Right. Because jurisdiction goes to the power of the court to act, jurisdictional defects cannot be waived, and for the same reason are not subject to harmless error analysis. Why are we bothering the Supreme Court with this? Why? Listen, it slams the door. It's the Lemke versus Ryan decision, 9th Circuit 2013. Our precedent makes clear, however, that a waiver of collateral attack must be express, and that a plain waiver of appeal does not suffice. So it should have never gone to the Supreme Court. And they quote that case, they cite U.S. versus Benbow, 9th Circuit 98. We have held that even where a plea agreement specifies that no appeal will be taken, it does not waive the right to bring a 2255 motion unless it does so expressly. And the government still doesn't do it. I see plea agreements without 2255 in it. And they cite U.S. versus Pruitt. Quote, a plea agreement does not waive the right to bring a 2255 motion unless it does so expressly. Thanks. At the end here, the last one, a plea agreement is a contract and is enforced as such. See U.S. versus Allen, citing U.S. versus Mondragon. U.S. versus Mondragon, interesting case. Before the plea agreement, we will not ask for more than this many months, we promise. And he signed the plea agreement. And then the prosecution sends a letter to the judge saying, we really think that it should be, 20 months more than that, or 24, whatever. And they brought up the challenge. They said that's a breach of the plea agreement. They didn't supply the judge with any new information or report on recent conduct committed after the plea agreement was signed. There's no reason to contact the judge. It's a way to ask the court to impose more than what they ask for when they go to sentencing and what's in the plea agreement. So the plea agreement's a breach, has been breached. And the 9th Circuit in Mondragon said that's right. It has to go back to the court for resentencing in front of a different judge. So yeah, it's a contract. Third thought bubble. Here's the statute that gives district court its jurisdiction. The district court will tell you this. 18 U.S.C. 3231. The district courts of the United States shall have original jurisdiction, exclusive of the courts of the states, of all offenses against laws of the United States. Well, it better be an offense. They don't have jurisdiction over anything else other than offenses under this statute. So once they discover there's no jurisdiction or the conduct was innocent, they've lost all subject matter jurisdiction. Listen to this. This is from Bond versus United States. I told you she went all the way to the Supreme Court claiming 10th Amendment rights to challenge. This is the dissenting opinion, or the separate concurring opinion by Ruth Bader Ginsburg I told you about. An offense created by an unconstitutional law, the court has held, is not a crime. See Ex parte Seibold, 1880. A conviction under such a law is not merely erroneous, but it is illegal and void, and cannot be a legal cause of imprisonment. Maybe that's why you can't waive those kind of challenges. I can't challenge an illegal conviction? Really? Because I signed a waiver? I can make legal that which is criminal? Come on. Wow. If a law is invalid as applied to the criminal defendant's conduct, the defendant is entitled to go free. Really? Okay. For this reason, she said, if the law is invalid as applied, invalid can be for this reason, for that reason, it wasn't properly enacted, it's unconstitutional, so forth. If it's invalid, the defendant's entitled to go free. For this reason, the court has no prudential license. That means a rule born out of convenience, to decline to consider whether the statute under which the defendant has been charged lacks constitutional application to her conduct. And this is so even where the constitutional provision that would render the conviction void is directed at protecting a party not before the court, like the states and the 10th Amendment. Our decisions concerning criminal laws infected with discrimination, Our decisions concerning criminal laws infected with discrimination are illustrative. The court must entertain the objection and reverse the conviction even if the right to equal treatment resides in someone other than the defendant. Because the law is being used to affect her, she has an interest. Let's see. They cite a couple cases on that topic. My quote of her separate concurring opinion concludes, in short, a law beyond the power of Congress for any reason is no law at all. See Negro versus United States, 1928. The validity of Bond's conviction depends upon whether the Constitution permits Congress to act. Her claim that it does not must be considered and decided on the merits. There's nowhere to run. And then the copy and paste of the plaintiff has challenged the charging statute as unconstitutional as applied to the conduct complained of, which is the subject of the matter jurisdictional challenge. Jurisdictional defects can include the constitutionality or unconstitutionality of the charging statute. Now, quoting the Supreme Court, 2004. Listen to this quote. Kontrick versus Ryan. In the 11th Circuit and 9th Circuit recently, Karen on the 9th Circuit and Chris on the 11th Circuit, they were told, because you didn't raise these issues in tax court, you can't raise them on appeal now. Well, a couple of them are constitutional claims. And all of them are jurisdictional, some based on statute. And they wouldn't hear them on appeal in a civil tax case. Quote from Kontrick versus Ryan, 2004 Supreme Court. A litigant generally may raise a court's lack of subject matter jurisdiction at any time in the same civil action, even initially at the highest appellate instance. See Mansfield versus Swan, Supreme Court, 1884, parentheses, challenge to a federal court's subject matter jurisdiction may be made at any stage of the proceedings, and the court should raise the question sua sponte, on its own. End parentheses. See Capron versus Van Norden, 1804 Supreme Court, parentheses, Judgment loser successfully raised lack of diversity jurisdiction for the first time before the Supreme Court. End parentheses. So there's nowhere to run for the dissent in this. Well, the rule provides, and it provides, and we have this rule over here, and there's no statute that says you can't waive that right. It's a skyhook. The dissent's opinion, they reached out and put a hook in a cloud, hoping it would support them. They got no grounds to stand on. My fourth thought bubble, their jurisdictional statement. Now, this is another way to deprive the court of subject matter jurisdiction. If you prove you're innocent, there's no offense before the court. It has to be an offense, remember, 18 U.S.C. 3231. Let's see. The district courts of the United States shall have original jurisdiction, exclusive of the courts of the states, of all offenses against the United States. If there's no offense, if you can prove innocence, the court's lost all jurisdiction, haven't they? Here's one way to prove innocence. It is well settled that when the law is vague or highly debatable, the defendant lacks the requisite intent to violate it. If the law is vague or highly debatable, you're innocent. So if you know enough about the law and you can challenge it, like I can in tax cases, I can fit somebody into this category. The law is vague or high. Hell, it's off limits in tax cases. So back to Rod Class's case here. You see that, and this is why I said punchline, and it takes you to the dissent's opinion, is because it's built of feathers and it's contract law. There's nothing complex here. The fact is the people that drafted the contract, the plea agreement, forgot their glasses or something. I don't know, spell check, whatever. The plea agreement didn't list all that it should list. And then there's the challenge that I could waive all day my right to challenge based on the Second and Fifth Amendment. It doesn't give the court any authority. I'll waive rights to do it, and then I'll do it. Because it's not a right I can waive. I can't give the court that authority. It has to come from Congress, and if it comes from Congress and it's unconstitutional, and it reached me at any instance, I can't contract the court out of their obligations to behave constitutionally. It can't happen. And I just showed you all the authorities in the world. No, I didn't. I showed you a smattering of authorities. I could spend a year reading those authorities to you if I went circuit by circuit. It's everywhere. This is simply the D.C. Circuit's attempt, or not attempt, they succeeded. We're going to screw with Rod Class. Send him up to the Supreme Court. Who cares? We don't have to hear this stuff. We're the D.C. Circuit. Next case. Okay, that's what life is like when you're a judge. So anyway, there's the Rod Class decision, and the point decided is very minor. It's not about the Patriot movement. It's simply about a guy that's affiliated with the Patriot movement. Congratulations, anybody affiliated with or even in work that makes the government call them affiliated with the movement, for you to be heard in the Supreme Court first is a miracle. More power to you. Right on. And then to get a favorable decision, that's icing. And even though it's on a small point, he had the resolve to go all the way. Right on. That's how it's done. That's what the Supreme Court is for. And you better have good issues by the time you reach there. And if you're going to litigate tax law, you start with the big issues to put the first court you go to in the uncomfortable position, as if you were going to go all the way to the Supreme Court. I create the biggest issues I can in the lowest court I go to, so that they're great big issues that are easy to steer through appeal, and by the time they reach the Supreme Court, they're so unconstitutional that they're attractive. So anyway, again, the Rod Class decision, more power to you. Congratulations. My hat's off to the guy, and he's got something to talk about now, and it's something to put over his mantle. And he goes back to appeal, and he might win. He had guns in his locked Jeep. Is that carrying a firearm? How come I have to check them at the border? Where do we stop and put our guns if we want to pursue our right to redress the government and drive from the 50 states into the federal capital to discuss business with our congressmen? We have to rent a hotel room now to leave our guns outside the... What are you trying to do to me here? That's the Second Amendment infringement he's alleging. And Fifth Amendment, may not carry. I wasn't carrying. They were stored in my vehicle under lock and key. So anyway, we'll see how it goes. It goes back to appeal now, and it should be a pretty short order on appeal, and more power to you on your future challenges. He pled guilty, but it's no big deal. And 24 days sentence with years of peeing in a cup in front of strangers. Yeah, I'd rather do without that. Sure, go for it, Rod Class. But he's got the constitutional challenge, headed for the Supreme Court again. Once this court rejects him again, he's going to appeal again, because he'll win in the Supreme Court on this one, on either the second or fifth, maybe both those grounds he's argued. My name is David Merlin. Thanks for joining me here at Codebreaker. I'll see you in the next presentation.